Good morning. I am Preeta Bagaji, and it gives me great pleasure to welcome you today to this webinar on data breaches. We thought that a discussion on this topic is particularly relevant at this point in time due to the prevalence of and intensity of data breaches in South Africa and across Africa, having exponentially increased in recent months and weeks. So this threat of the enemy at the gate is very, very real. In fact, this point hit home for me personally when I recently had my phone stolen in a burglary. I have since been bombarded with many different attempts to gain access to my personal information and my Apple ID and passcodes. In fact, many of these methods look so convincing and genuine that my heart has skipped a beat on more than a few occasions when I received these messages and calls thinking that a genuine attempt has been made to access my passcodes and the like. So this really demonstrates how deceptive, sophisticated, and persistent tactics are being used by the bad guys. So if I was rattled by this, how many people could so easily get caught who may not be aware, who may go into panic and click on a bad link? What if that is directed to access to your company network and not just a personal device? So it really can happen so easily. Today, we are going to share some valuable insights with you from our experience with advising on data breaches in both South Africa and Kenya. And undoubtedly, one of the most spoken about issues in this space at this time is ransomware attacks and what to do if you're faced with a ransom request. These raise moral, ethical, legal, and reputational dilemmas. Do you pay the criminals and restore your systems and prevent the publication of stolen data, but at the same time risk being criticized for fueling criminal activity? Or do you take the moral high ground, refuse to pay, but face substantial operational damage and the fallout of publication of sensitive information of customers and staff? So unless and until we have sophisticated quantum computing being used widely in our businesses, and of course the cyber criminals are not able to use the same high tech to hack into your systems, you really do need to be alive to the risks, be continuously vigilant, and of course not let your guard down. So the team from CDH will help today by sketching out the legal landscape in regard to data breaches and how to handle them. Tim Smith, a director in our dispute resolution practice, will join me in discussing the South African law applicable to data breaches. And then we're also joined by Shemo Tenga, our partner in IP and TMT in the CDH Kenya office, who will speak about what is happening in Kenya on this front. Our experience has shown that it's not just affecting the traditionally targeted sectors like financial services. Cyber attacks are now affecting any and all sectors and any and all size of business. Our guest speaker today, Danny Myberg, is going to speak to you about why this is the case and discuss the latest threats, how businesses fall victim to these attacks, and how to deal with them. Danny is the MD at Cian Ray, and also has other firms specializing in digital forensics, litigation support, as well as cybersecurity. He is also an associate professor of practice at the Northwest University. Welcome, Danny. So before I hand over to Danny, I'd like to invite you to post any questions you have as we go along on the chat function. We will have a Q&A session towards the end of our webinar, time permitting. Thank you, and over to you, Danny.
Excellent. Thank you very much, Peter. I really appreciate that. Just confirming you can see my slide?
Yes, we can.
Excellent. Good morning, ladies and gentlemen. It's such a pleasure chatting to you today, and I think such a relevant topic at the right time. Just to give you an idea before we kick off, we've literally so far this year done about 11 major or significant breaches in South Africa, some of which you would have seen and heard about in the news. So I think it's really great that we're having this discussion, especially today, with all of the stuff that's going on and the uncertainties that a lot of business managers are actually facing in terms of cybercrime. If we look at what the picture is currently in South Africa, we're seeing three main threats that is hitting organizations quite severely. The first one is a business email compromise. Business email compromise is basically where the hackers gain access to the mail account of a specific party, typically in the cloud environment, and they then crawl through that mailbox to see what transactions a person is busy with. So if they see that you are busy selling a property, or you are busy with, for example, waiting for your payment in terms of your retirement, for example, they will climb in between. We also refer to that as a man-in-the-middle attack. They will climb between those two parties, change the banking detail, falsify the invoice, and a lot of times they're emailing from that real mail account to that financial institution. So the severity of this is unbelievable. We are estimating that about $300 million is being lost on a monthly basis due to that. So we're working with a lot of these cases. We're working with the US Secret Service as well. The main problem is that communication is coming from the real mail account of the person in a lot of the cases, but really difficult for you to differentiate between what is real and what's fake. Then secondly, we've got hacking and ransomware attacks. Hacking with the aim of doing something mischievous or to steal data, your data exfiltrations, and on the other side where they're executing ransomware. So those two we're seeing more or less are running neck to neck currently. What we're also seeing is that with some of the stats that we collected ourselves, because it's really difficult getting statistics on South Africa. So in the past 24 months, we've been involved with about 58 major breaches in South Africa where we've assisted clients. So what we're seeing is that and if you look at the right-hand side of the screen, we're seeing a lot of double extortions taking place where the hackers are actually coming in, stealing your data and encrypting the data, and they extort you for both. At the bottom, you'll also see that we are seeing triple extortions taking place. Triple extortion is where they encrypt your data, they steal your data, and then they start mining that data. So a very prominent case that we had is TransUnion, where the hackers actually started working through that data and started contacting some of the data subjects and extorting the data subjects directly. So that's why we saw a couple of data sets of other previous breaches that the hackers also used as part of that extortion process. So there's a number of different things that we see that the hackers are doing. One of the very interesting ones is the cryptojacking. Cryptojacking is basically where the hackers would break into your network and transfer crypto mining jigs onto your environment. Unfortunately, what we're seeing is in many of these cases, it is actually the IT service provider or your IT staff that's actually using that background of the network to do the crypto mining. A lot of risks for organization. Number one, they'll motivate you to buy better and more expensive servers because they want more processing power. But then on the other side also, one of the first things that hackers are scanning for the environment is for cryptocurrency because they want to steal it. So that paints a target on the organization. We also had a couple of logic bombs. Logic bomb is a piece of code where in a certain condition it executes, typically being left behind by a disgruntled employee that execute a couple of months after he left an organization. Also typical of a disgruntled IT administrator a lot of times. So when you do exit an IT administrator, really important that you do it in the right fashion. Now, a lot of people ask me, but Danny, my data is not important enough. My company is not important enough. Why would they come after me? I don't have medical information, financial information. You guys, we are working for listed companies. We're working for small organizations. The hackers doesn't mind. You know, they'll stop you on the street and to steal your cell phone. What prevents them from sending out 1 million emails? And if you're unfortunate enough to click on it, and you've got 5,000 Rand, they will take that 5,000 Rand because it's really easy and they're not that time consuming for them to do. So the way in which the hackers do attack organizations, we do have industrial espionage, we do have some company to company type of espionage going on. We do have revenge attacks that's taking place, but the two main ones that we're seeing is drive-by shootings or the shotgun approach, where the syndicate would literally just mail out 1 million emails, and if you click on it, unfortunately, you fall for that scam. The one that's more concerning for us, and that's what we're seeing in South Africa currently, is the targeted attack or the big game hunting. Big game hunting is basically where the hackers would focus on an organization, do their background on that organization, and then specifically target and attack that organization. We see that their preparation phases takes up to 2 months in some instances. They will Google you, they will see who your financial directors are, your staff members is, they'll go into their social media profiles, see what their interests are, and they utilize all of that information to style their attacks specifically to compromise that individual. Just to expand maybe and share a war story with you, the organization or the threat actor that hacked TransUnion, we were monitoring them on behalf of a number of clients, and on the group where they threatened to release the information, once they had a big community that was following them and looking for them releasing this information, they actually started advertising blatantly to say, if you're working in an important industry like electricity or like medical environment, we would like to make contact with you because we're prepared to pay you money for you to facilitate access for us into that environment. So you're sitting with a situation of, doesn't matter how secure your systems are, how much money you're spending on that environment, if your employees are the weak link, it makes it really, really risky for us. So if we look at some of the breaches, the hackers do attack us by using a typical SWOT analysis. What's our weaknesses? What's the opportunities for them? So we are seeing that there's a lot of third-party breaches that's taking place currently. You might be the main responsible party, but that service provider that's sitting with some of your client data, providing services for you. Some of the most recent ones that we've worked on actually came from third-party breaches. Phishing attacks still very, very relevant, where the hackers are sending you fake mails. You click on it and then they attack you in that fashion. Then also we've got brute force attacks where they're guessing passwords, or they could buy databases from, if you go, for example, to the website Have I Been Pawned, and you then enter your email address there, it'll tell you previous breaches where your information was part of it, for example, password and email accounts that was breached. And then unprotected mail accounts where you don't have two-factor authentication, unprotected RDP, VPN sessions, outdated software. There's quite a lot. I'm going to show it to you now, how many known vulnerabilities there are in our old software. Firewall rules, open ports. You might think that somebody's looking after your firewall, but they're not really getting to it because they just have too much work, and it's been working in the past, so why is it not working anymore? So those type of things is where we see the hackers are coming in. Now, just to show you, this was a listed company that we helped with a breach, and they've got all the policies and procedures in place, but we found that 765 of their employees actually used password 01 as the password. So that's something that we can crack in a second. Password control, even if you've got password policies and all of that, we see that it is still being one of the biggest problems to get your personnel to use strong passwords. So if you look at the right-hand side, and unfortunately currently, Kaspersky, there's a lot of discussions whether American organizations should be using a Russian-based software in the security environment, but they've got a very nice tool where you can actually go and check the strength of your password. So in the past, you know, we always said to our personnel, use special characters and use long words. We can break that password in 1 second. The best passwords that you can utilize is string of a sentence or something, and then typically your English words is not the most secure. So rather go for African language and use a word from there. For example, just on the sideline, if you use the word boerenbors, it indicates that it'll take 3 to, I think, up to 2 weeks to crack that password. So here we've got a really old stat coming from 2019, but it's showing that up in 2018, we actually had 16,000 known vulnerabilities in some of the outdated softwares. On the right-hand side, you'll see that critical high security breach of vulnerabilities is only being fixed by IT guys 129 days to 195 days after that became known. So it's really difficult for us to keep track with all these security breaches that's going out. In an incident response, if a company is in trouble, the phases that we want to go through, and it's really important that you guys have incident response plans, that you actually test them, that you simulate them. So typically we go through containing it, preventing it from spreading further, eradicating it, get the hackers out. While we're working with that to get the hackers out, we're doing a lot of things like threat hunting, doing forensic collections so that we can come back and say exactly how it happened, how they got access, what else did they compromise, for example. We go through a process of remediating. Can we trust your backups? Can we restore that backups? We can't just restore it, and the hackers typically infect up to about 38 days worth of backups before they start executing ransomware. So we need to clean those, and then a lot of times, as Peter has also mentioned, we need to consider the ransom process. So just quickly to give you an idea, some of the surveys that was done indicated that up to about 40% of the companies or the victims actually admitted that they had to pay ransom afterwards. So that, if you take it into consideration that the ransom demands on average is about 6.4 million rand, the statistics are showing that an average breach cost the company in terms of business interruption, reputational damage, data subject notifications, can cost you up to 46 million. Then you can see why a lot of companies would consider making that payment, because sometimes it's cheaper making the ransom payment than actually trying to recover on your own from that disaster. So the business interruption that we're seeing, on average, we're seeing 11 days of downtime. There's a lot of statistics showing between 6 days and 47 days to recover from a breach like this. But it all depends on that organization. If we have a quick look at the typical ransom process that we go through, and as Peter has said, the most important thing is always to consider we don't want to negotiate with hackers. We don't want to support crime. We need to make sure, is it actually safe, and is it legal to actually pay the ransom? But typically what we do is we go through a process of doing an intelligence investigation on that ransom group. We don't want to pay a group that previously, when somebody paid them, they didn't give the decryption keys, for example. So there's a lot of intelligence that we do on the dark web regarding these organizations, the methodology that they followed, the type of ransomware that they executed, the crypto wallet that they're giving to us. All of that we need to follow a process. It's referred to as the OFAC process, where internationally you need to go and clarify actually whether that group is associated with a terrorist group or not. We go through that negotiations. We don't want to communicate from the client's mail account, because that communication can actually be used to further extort you. So we set up third-party mail accounts. We go through the process, try to bring the price down. Typically, we can do it between 15 and about 38% that we bring the price down. And then that's the facilitation of that ransom. And the last portion is the reporting duty that's on organizations to actually inform the authorities, etc. So in closing, there's a lot of things. Why do hackers want to steal our data? Well, obviously they can extort us because there is consequences for businesses. They want to do data enrichment. They want to do identity theft, social engineering with it. With the quantity of data of us that's out there, you can't trust anybody phoning you over the phone anymore and saying, I'm so-and-so from the bank. This call is being recorded for quality purposes. Can I confirm your ID or your car registration? The hackers have got all of that with the breaches that we've seen. So there's a number of things that we need to do. If your data is part of that breach, contact the organization, find out what's been breached, see what help they are giving you, change your passwords everywhere. Don't use the same password everywhere. It's best to have a password vault, for example. And then also you can consider stuff like implementing two-factor authentication, really good security for yourself, and just be vigilant with the information that you are sharing with organizations. Thank you very much. I think I am on my time. I hope that helped a little bit, and we'll take questions in the end. Thank you very much, Prieta.
Thank you, Danny. Right, hopefully you can see my slides. So following on from what Danny has just discussed with you, let's look at the legal side of this. So what happens if this happens to you? So the first thing you need is cool heads and calm decision making. When you are confronted with a data breach, there are a number of important levers that would need to be considered quite quickly. So while you are assessing what has happened, the extent of the breach, the data that has been impacted, you will be juggling a few or many balls against which strategic, time-sensitive decisions need to be made. And importantly, these need to be informed by relevant legal obligations. So what does this legal landscape look like? If we look firstly at the reporting obligation, so depending on the type of breach and the circumstances and the nature of your business and the specific laws that may apply to your specific business, you may have a number of different reporting obligations. The most obvious one, which we're going to unpack in this discussion, is the POPI notification requirements. Again, if it's a cybercrime, you may have notification requirements or obligations under the Cybercrimes Act. And then if you are deciding on paying a ransom in a ransomware attack, you've got to look at taking the considerations that Danny has also mentioned into account. You've got to look at what is the least worst scenario. So from a legal perspective, the payment of a ransom is not of itself illegal in South Africa, but it depends on who the money is paid to and what the circumstances are. And so consequences need to be very carefully considered. Tim is going to speak to you in a bit more detail about this and cover things like money laundering, financing of terrorism, sanctions, exchange control consequences, and how to navigate that. But really, what would you do if a ransomware attack was, and your business is a hospital, and the ransomware attack was such that it shut down critical operations such that you couldn't give critical care and perform life-saving operations? This is a vexed issue that is one that decisions against can't be made lightly. The next consideration is obviously managing reputational risk. And again, this requires clear minds to determine these risks and how best to address them. Many of these are often also driven by legal considerations, reporting obligations, transparency, how quickly you inform the media, you inform affected customers or staff in order to take appropriate steps to mitigate the risk to themselves. You also need to consider notifications under contracts. Who did you commit to advise of these occurrences? Also consider confidentiality obligations under relevant agreements. Then we turn to managing system and technology risks. So for cyber incidents, taking steps quickly to stem the bleeding and to patch the wound is important. Danny's discussed this. But here you also need to ensure that while you do that, you at the same time make sure that you preserve the evidence of where the point of entry was, what has happened, what data has been compromised. And this is also relevant if it's a cybercrime and you need to assist the police in the investigation in that crime. Managing business continuity is also something to consider. Making sure you keep the lights on and your business can continue is always going to be paramount. But consider the legal ramifications if you cannot deliver services or products under contracts with your clients and customers, for example. And then also consider the down the line troubles. So the claims that could arise from those contracts that you weren't able to fulfill because the attack stopped your systems. It shut your systems down such that you couldn't deliver services and goods to your customers. Obviously, there would also be the risk of claims from the people affected and the companies affected in the attack, whose data was compromised, and they may come after you for damages. Then claims under POPI are also relevant. Potential fines under POPI and other laws need to be considered. Tim is going to look at that in more detail in a moment as well. And then also where you have large amounts of data, a lot of people impacted, following on from what Danny said, is that you in fact have huge costs to deal with data breaches. And this includes costs of advisors, investigators, dealing with legal claims, even possible class actions, the technology fixes and system changes and upgrades, as well as internal resource costs, which can also amount to a significant number given the scale of some of the breaches that we see clients experiencing. So the upshot of this, that you need an effective risk mitigation plan. So being prepared is key so that you can achieve the cool heads and clear minds objective when you do have a data breach impact your business. So let's have a look at what being prepared means. So I do see many clients realize their compliance lapses or weaknesses in their processes or lack of efficacy in training and awareness programs only when a breach happens. So key to your armor is, in fact, being properly prepared. And I start with policies and procedures. And the point I want to make here is that you may or may not have very good policies and procedures already in place for your business, but effective policies and procedures are really key, especially where a data breach occurs. And along with that, mature data processing compliance practices. So even if your policies are simple, they need to be implemented and in operation and workable and right-sized for your organization's requirements. So looking at it from a data breach perspective, how does compliance with a focus on POPI look like? You need effective data breach response plans, incident management plans tied to understanding the obligations that you have under POPI, along with managing all the risks that I spoke about in the previous slide. Then effective data record keeping or data processing record keeping, which is also a requirement under POPI, helps with data breaches because then in respect of understanding quite quickly what personal information has been breached and what is secure, having effective data mapping and data classification across your business helps you minimize the time taken to identify what personal information is impacted. And this is particularly important when I come to the slide on notification obligations and the timing around that. Then the principle of data minimization and effective retention and disposal procedures is also relevant. If you've implemented those requirements of POPI effectively, then when a data breach occurs, you are less likely to have reams of historic information sitting on servers that may be accessed and exfiltrated. So it helps to minimize the extent of and impact of a data breach. De-identification and anonymization practices, also a requirement under data protection laws, is a good tool from a data breach perspective as well. It's an extra level of security. And then staff training and awareness is a key note. In a mature data compliance environment, your staff know exactly how to manage the risk and are clear on seeing the risks and understanding the latest threats. And so they are properly prepared if the inevitable does occur. And third-party management is the next component of a mature data processing compliance program. And this is something that is a real risk that we see fairly often. And sometimes it results in significant breaches, and sometimes just small ones and small lapses. But this is a requirement in terms of you understanding where the data is leaving your organization and how that is happening, and who is doing or who is manning that, and how that manning and who is the gatekeeper, and what rules apply to that gatekeeping. And often this is managed via contracting. It's not the only way, but from a legal perspective, effective contracting for under POPI, the likes of a operator or processor agreement, relevant data sharing agreements, as well as cross-border data transfer agreements are vital and necessary, but they also help with setting the rules and procedures so that you can effectively manage a data breach situation, either obviously mitigating and preventing it as far as possible, but also managing the impact of that where it does occur. And another obligation is and really in line with how these threats and the nature of these risks are evolving at a breakneck speed, it would seem, is that you need to keep your protocols and policies and procedures updated. So that the mature data protection program would build that into its mechanics, and part of that is also driven by Section 19 compliance under POPI. And then the last point on this slide is don't forget about the paper. We've had a clear focus in this discussion so far on electronic records, electronic data, and the threat in that regard. But the threat in respect of data breaches occurring where paper documentation is involved is also prevalent, and it's a real threat. So all of these plans and procedures and the being prepared is also relevant and should encompass understanding where your paper documents are and how that is managed. So even if you have all of what I said ticked in the box, or if what I've said is sparking some thoughts and you're going to go back and check that your organization has all of this in place, we now turn to if and when a data breach actually occurs and POPI is applicable, then how do you unpack that notification requirement? So I'm going to go through this very quickly because we're running out of time on my slot, and it is a topic that we can talk about for a very long time. The requirements of POPI are very different to other pieces of legislation, notably the GDPR. And so when we are faced with a data breach incident, you need to look at what POPI says about a data breach. And a trigger for reporting is where there are reasonable grounds to believe that data has been accessed or acquired by an unauthorized person. And I'd love to talk to you about many different examples and how this applies in practice. But suffice to say that we don't necessarily have a risk-based regime under POPI. It is a factual determination. In each case, you've got to look at what has happened, whether data has been compromised, and how that patches up to the requirements of the legislation. Then a note on who to notify and why. With POPI, you have no choice. Unlike other data protection laws, you have to notify both the information regulator as well as the data subject if your breach fits with the requirements of Section 22 that we spoke about on the previous slide. And then another issue is, how do you identify the impacted data subjects? So this can also be difficult to do. And again, the facts will determine whether you notify all of your data subjects. And in other words, if you're unable to pinpoint where the breach has actually occurred, so this is, for example, with a ransomware attack, you may need to notify all your data subjects out of an abundance of caution. Alternatively, where it's a specific incident and you can identify the data subjects, then it would be those specific data subjects that are told in compliance with the requirements of POPI. And if you are completely unable to identify the data subjects, in that case, POPI says that you don't need to notify data subjects quite evidently. Right, so the timelines for notification, there isn't a set time in POPI. It is as soon as reasonably possible after the discovery of the compromise. So in respect of timing, what is a reasonable time will also depend on the circumstances. But I think the rule of thumb is, as soon as you're able to determine what the breach is and the fact that data subject information has been compromised, your notification obligation would trigger. How to make the notification? So you would write to the regulator, but how do you notify the affected data subjects? Typically, it would be via email or in on your website, for example, and you could also print it in the media. What to disclose? It's enough information so that the data subjects can take appropriate protective measures. And the question often arises is, what happens if it's a small or insignificant breach? And in this case, again, it will depend on the facts and circumstances as to whether a notification is triggered. So this often encompasses the finger trouble type breaches. And then just a point on operator responsibilities. If you are an operator, then you must notify the responsible party immediately. This is a requirement under the legislation. Okay, and then to end off very quickly, a note on third-party risks. These are really often the unseen risks, and in many cases we see clients not having a full understanding or appreciation of who has access to their data systems, premises, and the like. And effective contracting is the answer here. So with that, I will hand over to Tim.
Excellent. Good morning. I just want to make sure that everyone can see my presentation.
It's almost
Yes,
up
we
to.
can.
Yes.
Excellent. Thank you. So I'm Tim Smith. I'm a director in Cliff Decker Hoffmeyer's Dispute Resolution Department. And today I'm going to be offering my insights in regard to the legalities surrounding ransom payments and damages claims arising out of data breaches. So in terms of my segment, I will be proffering insights from the perspective of a responsible party which has suffered a data breach. So let's set the scenario. For the purposes of the example that I will use today, let's say that your company manages the investments of high net worth individuals. You learn that your company's service provider, which provides data hosting and cloud services to your company, has suffered a data breach, and that your client's sensitive wealth details and personal information are the subject of a ransomware attack. The hackers demand payment of 100 Bitcoin for the decryption of the data and for its deletion from their system. So the question that arises is it legal to pay a ransom in South Africa? Danny touched on it. The crime is that is being committed by the hackers in demanding payment for the decryption of the data and its deletion from their systems is one of extortion. Extortion is defined as a person unlawfully and intentionally obtaining some advantage. In this case, it would be the payment of money from another by subjecting them to pressure which induces them to submit to the demands. What this means, in my example, is that your company has been the victim of the crime of extortion. In South Africa, there is no legal principle which makes the payment of a ransom illegal, but that does not mean that the party in respect of which the ransom demand is made, so the company in this instance, can abdicate its responsibilities and not properly consider the facts surrounding the demand that has been made. In this regard, the Prevention of Organised Crime Act and the Protection of Constitutional Democracy Against Terrorist and Related Activities Act make it an offence to provide financing to terrorist organisations. Thus, to the extent that your company establishes, knows, or ought to have reasonably known that the hackers, to the extent that you're able to establish who they are have affiliations to a terrorist organisation or are themselves a terrorist organisation, then it would be unlawful in terms of the legislation I've referenced to make payment of the ransom to those organisations. Accordingly, your company would need to conduct some sort of investigation in regard to the hackers to the extent that it is able to determine whether the hackers have any terrorist affiliations. The legalities that then follow after, let's assume for the purposes of this example that the decision is made to pay the ransom because the hackers don't have any affiliations to terrorist organizations. The legalities that follow the decision to pay the ransom are such that, having assessed the hackers, if they are not a terrorist organization or linked to a terrorist organization and the payment is made, what are the requirements that follow? Well, in terms of Section 34(1)(b) of the Prevention and Combating of Corrupt Activities Act, there is a duty to report the crime of extortion to a police official. Then, in terms of Section 7(1)(b) of the Prevention of Organised Crime Act, there is a duty to report the transaction to a person designated by the Minister. In terms of Section 29 of the Financial Intelligence Centre Act, there is a duty to report the transaction to the Financial Intelligence Centre. In terms of Section 34 of the Prevention and Combating of Corrupt Activities Act, there is also an obligation to report. It must also be noted that electronic communication service providers and financial institutions are also required to report the breach of their system to the South African Police Service within 72 hours of discovering the breach in terms of Section 4 of the Cybercrimes Act. We then move on to having made the payment to the hackers and the data is decrypted and deleted from their systems, or so you're told. 2 weeks later, in terms of the example I'm going to give you, you're notified that your top 3 clients have each had 10 million taken from their accounts, the details of which were contained in the data that was the subject of the breach. That then gives rise to a potential damages claim for those clients against you, the responsible party. Section 99(1) of POPI provides that any data subject may, or at the request of the data subject, the information regulator may, institute a civil action for damages against a responsible party, in this instance, the company whose customers' accounts were hacked, which fails to adhere to the provisions of POPI as referred to in Section 73, whether or not there is intent or negligence on the part of the responsible party. As such, POPI imposes strict liability. Negligence or intent are not requirements on a responsible party, but only to the extent that there has been a breach of the conditions for lawful processing of personal information, or of sections 22, 54, 69, 70, 71, or 72 of POPI, or the Code of Conduct issued in terms of section 60. Section 99(2) then provides the defences that the responsible party would be entitled to raise in relation to a damages claim brought under section 99(1). And those defences are force majeure, a consent on the part of the plaintiff or the party whose data was breached, compliance was not reasonably possible, and or fault on the part of the data subject in allowing the damages to occur. And section 99(3) of POPI then provides that a court hearing the matter may award an amount that is just and equitable, including payment of damages as compensation for patrimonial and non-patrimonial loss, aggravated damages, which are understood to be punitive damages, interest and legal costs. Now, in terms of a claim brought in terms of section 99(1) of POPI, all that a data subject would be required to allege under a damages claim is that the harm suffered by the data subject flows from the unlawful conduct of the release, processing, disclosure, and or unauthorized access of the data subject's personal information. Both patrimonial, which is monetary loss, and non-patrimonial loss, which are personality rights and would include losses for pain and suffering caused by the breach, are included in the damages that could be awarded. A quantification of any claim will be limited to what is just and equitable, and each case will have to be determined by the courts on their own merits, having regard to the facts and circumstances in those matters. It is important to note that aggravated damages or punitive damages, as provided for in section 99(3), is a concept not recognised by South African common law. In all probability, under this section, a claim for punitive damages will be sought, but a court would have to consider whether a further award for damages of this nature is justifiable, where the data subjects have already been or are compensated in terms of section 99(3)(a). It is also important to note that a data subject is not limited to a claim in terms of section 99 of POPI, but may also claim against the company in terms of contract, to the extent that the company has a contract with the data subjects, or the data subjects may have a claim in delict. Apologies, I have missed a slide. Some other important factors to consider, and I see that it is a question that was asked in the chat. It is important to note that the company itself may have an indemnity claim against the operator. So in this instance, you'll recall that it was in fact a service provider to which the company had contracted that was breached, that resulted in the customer's data being utilized against them. And in this case, the company may have a claim against its operator in terms of its contract with the operator, or in terms of delict, in circumstances where the company has suffered damages as a result of the acts or omissions of the operator. Now, to the extent that there is a contract in place that has an indemnity limit in it, then in those circumstances, the responsible party or the company would be limited to the extent of the indemnity limitation contained in the contract. So it's important to know that when drafting those contracts, that the indemnity provisions need to be very carefully considered. There are some other important considerations to keep in mind if a data breach occurs. And in this regard, there are a number of insurance providers offering cyber risk cover, which policies often cover claims arising out of data breach incidents, such as business interruption claims, claims against the company by data subjects, etc. So it is important that where a cyber risk policy is in place, that the policy and its coverage is understood, and that the company does not take any steps that might compromise any claim that the insurer might have. Such steps would include paying a ransom amount if the policy is to respond to the claim, as if the company were to compromise the claim, that could result in a rejection by the insurer, So if the company pays the ransom amount without reference to its insurer, the insurer could then reject the claim as there would have been a compromise of the insurer's rights. The insurer must also be appraised of the incident as soon as possible after it's discovered, and the insurer must be kept appraised of all developments. So thank you. That then closes off my portion of this presentation. I'll now hand you over to my partner in Nairobi, Shem Otanga, a director in our Kenyan IP and TMT department, for his insights from a Kenyan perspective. Over to you, Shem.
Can you hear me?
Yes, we can.
Can you see my slides as well?
Yes, we can, Shem.
Right. Good morning, everyone. My name is Shem Otanga. I'm a partner, as my fellow partner in South Africa, Tim has mentioned, in the Nairobi office. I head the IP and TMT practice here. So I'll be giving a brief Kenyan perspective on the practicalities and difficulties of data breaches within the East African environment, and particularly the Kenyan one. So I'll begin with an insight on when the breach notification criteria, or rather when the notification obligation arises, or what criteria is used to determine whether there's an obligation to notify the regulator in Kenya concerning personal data breaches. The Act has been very clear regarding what constitutes a personal data breach. There is a definition that is provided in the Section 2. For the sake of time, I won't read through it, but I'll focus on the notification criteria. And essentially, wherever you have unauthorized access or acquisition of personal data, and there is a consequential real risk of harm to the data subject, then and only then is the obligation to notify then triggered. So it's not in all circumstances that notifications are required, but only where a consequential real risk of harm arises from the data breach. Now, the law has gone further to sort of explain and to clarify when a real risk of harm is deemed to arise. And there are two separate, though linked, situations where this real risk is deemed to arise. Firstly, where the data subject's name or ID number is disclosed, together with a certain specified or stipulated category of personal data types or classes, which are set out in the second schedule to the general regulations that came into force in March this year. So a data subject's full name or ID number, together with details such as their salary, their creditworthiness, bank account number, credit card number, details regarding, for example, their medical health treatment. When those two are released or disclosed or breached together, then a real risk of harm is deemed to have arisen, and generally the obligation to notify the commissioner arises. The second situation where the obligation to notify is triggered is where you have a data controller or data processor that maintains an account on behalf of the data subject. And the account identifier, together with the security information of the passwords or whatever is used to access those accounts, is actually disclosed or breached. So any entity really, or any processor or controller that maintains accounts would fall under this category and would find themselves being faced with a situation where they have to actually make the notification to the commissioner or to the data subject. Now, very quickly, to whom do the notifications need to be made? I've mentioned the data controller. There's a timeline stipulated under our law, which is without delay and within 72 hours, and where that timeline is not met, the reason for the delay has got to be provided to the commissioner. Also, the data subject needs to be notified within a reasonably practical period. No timeline is set out there specifically. but it needs to be reasonable, right? But it's not in all cases that they have to be notified. So the notification may be withheld where, of course, naturally where you cannot identify who the data subject is, or where you already implemented certain safeguards, such as encryption of the data. You need not notify the data subject. The notification of the data subject may also be delayed in instances where you want to investigate a crime or detect one, etc. And the final obligation of data controllers in respect of such data breaches is to record the facts of the breach, the effects, and the remedial action that has been taken following the breach. The processor only has to notify the data controller in Kenya. That's within 48 hours, basically. Now, very quickly, just to talk about some of the practicalities. There's been a high level of cyber attack incidents reported by the Computer Incident Response Team, which is a subset of the telecoms regulator in Kenya. 79 million up until March of this year, between January and March of this year, 79 million cyber attack incidents in those 3 months. So it's a very high level, very high number of incidents occurring in this part of the country. There's of course limited capacity for enforcement. Arrests cannot be made where you have, such ridiculous numbers. Arrests of all the people involved can certainly not be made, and there's no capacity for enforcement and prosecution where you have this level of incidents arising. Again, we're seeing an increased level of sophistication in cybercrime tactics that are occurring. No one is immune. The Kenya Revenue Authority a few years back suffered from an account breach that led to the loss of $39 million US. And these are government entity. Of course, following that, they tendered for an upgraded security system and all, but it just went to show that no one really is immune, and one does well to be on one's guard at all times. The borderless implications of the complexion of cybercrime also makes it difficult for us in our country to sort of enforce the requirements of the law locally. WannaCry happened a few years ago, and Kenya was not exempt, and around 19 institutions were affected by that ransomware incident, including banks. And of course, the issue of payment of ransomware arose. The regulator encouraged, or rather, I should say, put out the view that payments ought not to be made because this just validates the business model that the hackers really had. So the idea was not to discourage those who are affected from actually making any payments. And in any event, as I've been mentioned during this webinar, there's no guarantee really that you would receive your data back or that you'll be able to reverse the incident upon payment of the ransom. So in the WannaCry incident, for example, it was investigated and found out that there was limited capacity or no capacity for the hackers to actually link payments to specific computers or data sets. So basically, they couldn't return your data. We do have a law that deals specifically with ransomware and the demand for ransoms under such circumstances, and it creates an offense, the offense of computer fraud, and provides for penalties that are quite wide and ranging. So you have jail terms, with the highest jail term being life imprisonment and the highest fine being 25 million Kenyan shillings, approximately 200,000 USD. And just to close it off, it's important to remember that breaches can occur not just digitally, but also through more traditional means. A few months ago, the guest list, the local Radisson Blue, was circulated on social media. Someone just took a picture with their phone and shared it on WhatsApp, and it ended up on blogs and WhatsApp groups all over. And complaints were made to the data commissioner locally concerning this breach, and the same is still being processed. The local regulator, of course, has adopted a more reconciliatory approach to aid compliance among stakeholders as opposed to waving a big stick and imposing sanctions at this point in view of the fact that the implementing regulations are still very new in our jurisdiction. So we've run out of time on this, but I'll hand over to Prita to perhaps take a question or two and just land the plane. Prita.
Question, I'll jump in there to help Peter with
Thanks,
that. No problem, Peter. So in terms of questions, we have hit 10 o'clock, but I think we can take one. The one question that I have seen, Danny, was from Renee Plitt, who asked, how safe are digital safes? For example, Splash ID. I don't know if you've got any insight in regard to that question.
Tim, yes, my apologies.
Sorry, Danny.
Tim, sorry, I saw it late. I just posted the question. Yes, it's really advisable to use something like a password safe. Not all of us can actually remember all our different passwords. Just make sure that you don't download something that's free, rather pay for it, and do a bit of research. Make sure that it encrypts your passwords and it works actually fine. I've got all my family's passwords in one location and it shares across all our devices. So it's really advisable.
Excellent. Thanks, Danny. That then concludes our presentation for today. I just want to thank everybody for attending the webinar today. We trust that this presentation was helpful in assisting you develop a better understanding of the practicalities and difficulties surrounding data breaches. A special thank you to Danny Marburg and Sianray for their inputs in regard to today's session. To the extent that you have any questions that we were unable to answer today, or if you would like us to consider a question or issue that you might have outside of this discussion, then please feel free to contact us via email or simply call directly, and we will then respond to your questions directly. So in closing, with the enemy constantly trying to find a way through the gates, Cliff Decker, Hoffman, and Sianray are here to help you, are here to provide you with the necessary support. Thank you again for attending today, and we hope to engage with you again soon. Thank you.